Can you imagine a witness lying under oath just to establish the guilt of a person in a criminal case or establish fault or culpability in a civil case? Since judgment based on a false testimony can destroy the life or property of an innocent human being, it is but necessary that this reprehensible act should be punished. And that is why today we will be discussing the crime of false testimony under Articles 180 to 182 of the Revised Penal Code as amended. Now, what is false testimony? False testimony is committed by a person who, being under oath and required to testify as to the truth of a certain matter in a civil or criminal case pending before a court, shall deny the truth or say something contrary thereto. To repeat, false testimony is committed by a person who, being under oath and required to testify as to the truth of a certain matter in a civil or criminal case pending before a court, shall deny the truth or say something contrary thereto. Let's take a closer look at the underscored portions of the above definition. First element, the phrase committed by a person. This refers to a witness, be he the private complainant or the accused in a criminal case, or the plaintiff or defendant in a civil case, or any other person who voluntarily testifies or is called upon to testify. Who is a witness? A witness under Section 20, Rule 130 of the Rules on Evidence is any person who can perceive and perceiving can make known his perception to others. Now, when the rule says any person can be a witness, it includes any person, regardless of age, gender, race, religion, political belief, or station in life. What is important is that such person can perceive and make known his perception to others. How then do we perceive? This starts with our 5 sensory receptors: our sense of touch, sense of taste, sense of smell, sense of sight, and sense of hearing. And they are transmitted to our brains where we organize the information we receive. Here are some examples. X saw Y stab Z. X heard Y tell Z, I will kill you. X, who acted as a poster buyer during a buy-bust operation, received the sachet containing white crystalline substance from the suspected drug pusher. Y, at gunpoint, forced X to drink a bottle of poison. X, however, survived. X, while conducting a roving patrol, smelled the odor of marijuana emanating from a dark corner of the street. In the above examples, if X is called upon to testify what he saw, or what he heard, what he touched, what he tasted or smelled, how then can he make known his perception to others? In other words, what are the ways by which a person like X in the example can communicate to others what he had witnessed? They are done through verbal communication, which must be in a language or dialect that can be understood by the court and the parties to the case. They can also be done through non-verbal communication, like sign language, the body language of the witness while testifying, his gestures, and facial expressions. Of course, the most important here is verbal communication. He must be able to communicate what he saw, what he heard, what he touched, tasted, or smelled by means of words, by means of a language which can be understood. Now, this must be so because even if X can perceive, yet if he is unable to communicate what he had witnessed, then he will not be allowed to testify. And if he cannot testify, then there is no testimony to speak of. Let's go to the second element, the phrase under oath. This is very important. Before a witness is allowed to testify, he must first take an oath. The wordings of an oath are usually as follows. I, Juan de la Cruz, if your name is Juan de la Cruz, do solemnly swear that I will tell the truth and nothing but the whole truth. So help me God. Ano ba itong oath? And ano ba ang importansya ng isang oath? An oath is an attestation by which a person signifies that he is bound in conscience to perform an act faithfully and truthfully. It involves the idea of calling on God to witness what is averred as truth, and it is supposed to be accompanied with an invocation of his vengeance or a renunciation of his favor in the event of falsehood. In other words, when a witness is under oath, he is bound to tell the entire truth no matter what. Otherwise, such witness will be held criminally liable for false testimony. Now, its importance lies in the fact that a person cannot be made liable for the crime of false testimony even if he denies the truth or says something contrary thereto when the same is not under oath. To repeat, kailangang before mag-testify yung isang witness, he must first take an oath. Because if he does not take an oath, no matter how untruthful his testimony may be, he cannot be held liable for false testimony. Let's go to the third element, the phrase required to testify. This includes being compelled to testify through a subpoena issued by a court or volunteering to testify even if not subpoenaed by the court. Now, what is a subpoena? A subpoena is a process directed to a person requiring him to attend and to testify at the hearing or trial of an action. This is based on Rule 21, Section 1 of the Rules of Court. Take note that the failure by any person without adequate cause to obey a subpoena served upon him or her shall be deemed a contempt of the court from which the subpoena is issued. You will be punished for contempt of court if you fail without justifiable reason to honor a subpoena. In case of failure of a witness to attend, the court issuing the subpoena may issue a warrant to arrest the witness and bring him or her before the court where his or her attendance is required. Fourth element, the phrase as to the truth of a certain matter. Here, the witness who testifies must tell the truth of what he personally saw, what he personally heard and or observed with respect to the facts in issue in a civil or criminal case. By the way, what is truth? Simply put, truth is the fact about something. For example, X saw Y stab Z. If X is called upon to testify in a criminal case for homicide, he must tell the court what he actually saw. That is, that Y stabbed Z. Take note that telling the truth, whether in a civil or criminal case, is the primary and most important obligation of a witness. Fifth element, the phrase in a civil or criminal case. What is a civil case? A civil case or a civil action is one by which a party sues another for the enforcement or protection of a right or the prevention or redress of a wrong. This is based on Rule 1, Section 3A of the Rules of Court. For example, X borrowed 1 million pesos from Y. X failed to pay despite demand. Here, Y can file a civil case against X to enforce his right. That is, his right as a creditor to collect the debt from his debtor, who is X. Take note that a civil action may either be ordinary or special. Both actions are governed by the rules for ordinary civil actions, subject to the specific rules prescribed for a special civil action. The fact that an action is subject to special rules other than those applicable to ordinary civil actions is what makes a civil action special. Now, I am only stating this or differentiating ordinary from special civil action to reinforce the fact that a person who testifies falsely either in a special civil action or in an ordinary civil action is liable for false testimony under Article 182 of the Revised Penal Code, which I will discuss in more detail in the succeeding slides. Now, here is a list of some of the ordinary civil actions for purposes of familiarity. Annulment of judgment. We also have annulment of marriage, annulment of sale, annulment of title, breach of contract, cancellation of title, damages, easement, issuance of owner's duplicate of transfer certificate of title, original registration of title, reconveyance, reconstitution of title, recovery of ownership, recovery of possession, replevin, rescission of contract, specific performance, and sum of money or collection of a sum of money. Of course, I will not be discussing each of these civil actions, ordinary civil actions at that. I am just stating this so that you can familiarize yourselves of these so-called ordinary civil actions. Here is a list of some of the special civil actions. We have petition for certiorari, petition for contempt, petition for declaratory relief, petition for expropriation, action for forcible entry, petition for the foreclosure of a real estate mortgage, interpleader, petition for mandamus, partition, prohibition, petition for quo warranto, and action for unlawful detainer. Take note that while the crime of false testimony applies to both ordinary and special civil actions, it does not apply to special proceedings such as adoption, rescission and revocation of adoption, cancellation or correction of entries in the civil registry, change of name, declaration of absence and death, guardianship and custody of children, petition for habeas corpus, hospitalization of insane persons, trustees, settlement of estate of deceased persons, voluntary dissolution of corporations, and constitution of the family home. This list is a list of the so-called special proceedings. To repeat, the crime of false testimony applies only to ordinary and special civil actions. It does not apply to special proceedings. Thus, even if a witness in an adoption case, for example, which is a special proceeding, knowingly gives false testimony with respect to the issues presented in the said case, such witness will not be criminally liable for false testimony for the simple reason that an adoption case is a special proceeding, not a civil action. To repeat, the crime of false testimony applies only to ordinary and, to a certain extent, special civil actions. It has no application to special proceedings. On the other hand, ano ba itong criminal case? A criminal case or a criminal action is one by which the state prosecutes a person for an act or omission punishable by law. This is based on Rule 1, Section 3B of the Rules of Court. For example, X was caught in the act in possession of an unlicensed firearm. Subsequently, a criminal case for illegal possession of firearm was filed against him in the regional trial court. Now, possession of an unlicensed firearm is a violation of Republic Act 10591, a penal law. X will now be prosecuted, and if proven guilty, he will suffer the penalty prescribed by law for the said offense. Now, whether the prosecution is for an act or omission punishable under the RPC or in special penal laws is a criminal case. Lahat yan, ang tawag dyan, criminal case. Whether the crime is punished under the revised penal code or punished under a special penal law. Let's now go to the sixth element, the phrase pending before a court. The word pending means that the criminal case is still on trial. It also means the case is not yet decided, or it means the case is still in continuance or awaiting decision. The term court refers to our regular courts. The first level courts like the municipal trial courts or MTCs, the municipal trial courts in cities or MTCCs, the municipal circuit trial courts or MCTCs, or the metropolitan trial courts or METTCs. It also refers to our second level courts. I am referring to our regional trial courts. Let's go to the seventh element, the phrase shall deny the truth or say something contrary thereto. How does a witness deny the truth or say something contrary to the truth in a criminal case? There are two kinds of false testimony in criminal cases. The first kind is the crime of false testimony against the defendant. This is found in Article 180 of the Revised Penal Code. Here, the offender who gives false testimony against the accused knows that his testimony is false. For example, X saw Y walking together with Z on the day Z was killed. However, at the trial, X testified that he saw Y kill Z, when in truth, he only saw Y walking together with Z. Now, we must remember that it is only after the accused against whom the false testimony was given is either acquitted or convicted by final judgment can the witness who gave such false testimony be prosecuted for the said crime. Here are some examples. Example number 1. In a case for estafa, X falsely testified against the accused Y. The court convicted Y. Y, however, appealed his conviction. Question: can X be prosecuted for false testimony? The answer is no, not yet, because Y's conviction is not yet final. Example number 2. Suppose Y did not appeal his conviction. Can X be prosecuted for false testimony? The answer is yes. The conviction becomes final after the lapse of 15 days from promulgation of the judgment of conviction. Example number 3. Suppose Y was acquitted of the charge. Can X be prosecuted for false testimony? Yes. A judgment of acquittal is already final. It can no longer be the subject of an appeal. Why? Because to allow the prosecution to appeal a judgment of acquittal will violate the constitutional right of an accused against double jeopardy. Also take note that Article 180 punishes the mere giving of false testimony. It is not necessary that the accused against whom the false testimony was given should be convicted. Question: what is the penalty for the crime of false testimony against the defendant or accused under Article 180 of the Revised Penal Code? The penalty shall be as follows: reclusion temporal if the accused against whom the false testimony is given is sentenced to death. Prisión mayor if the accused against whom the false testimony is given is sentenced to reclusion temporal or perpetua. Prisión correctional and fine not exceeding 200,000 pesos if the accused against whom the false testimony is given is sentenced to any other afflictive penalty. For example, prisión mayor. Arresto mayor and fine not exceeding 200,000 pesos if the accused against whom the false testimony is given is sentenced to a correctional penalty, like prisión correctional, arresto mayor, or destierro, or a fine, or is acquitted. Rather, if the accused is sentenced to pay a fine, or if the accused is acquitted. Question: what if the accused against whom the false testimony was given is sentenced to a light penalty only, like arresto menor? Is the witness who knowingly gave such false testimony liable? The answer is no. The witness who gave such false testimony is not liable. Why? The reason is Article 180 is silent on this matter, meaning the article does not impose a penalty in case the accused against whom the false testimony was given is sentenced to a light penalty only, like arresto menor. This is apparently a legal inconsistency because with more reason should the witness be punished for falsely testifying if the person against whom he gave false testimony is convicted, rather than if he is merely acquitted. The second kind of false testimony in a criminal case is the crime of false testimony favorable to the defendant under Article 181 of the Revised Penal Code. Here, it is also required that the offender who gives false testimony knows that his testimony is false. For example, X saw Y kill Z. At the trial, X testified that he did not see Y kill Z when in truth he is an eyewitness to the crime. However, unlike Article 180, where there must first be an acquittal or conviction by final judgment before a witness who gave the false testimony can be prosecuted, here it is enough that the accused in whose favor the false testimony was given is prosecuted for a felony punishable by an afflictive penalty or by other penalty. Question: is it required that the false testimony favorable to the accused should influence the decision of acquittal? Or is it required that the false testimony should benefit the accused in whose favor the false testimony was given? The answer is no. It is enough that the witness testified with the intent to favor the accused. Question: if it is the accused who takes the witness stand and falsely testifies to favor himself, will he be liable under Article 181? The answer is, it depends. For example, X killed Z. At the trial, X denied having committed the crime and instead pinpointed Y as the one who killed Z. Is he liable for the crime of false testimony favorable to the defendant under Article 181? The answer is yes. An accused's right to testify is to enable him to tell the truth within his knowledge that will establish his innocence, not that he may falsely impute to another person the commission of a crime, as ruled in the case of U.S. versus Suleiman. Another example. In the above example, if X merely denies committing the crime, is he liable under Article 181? What I mean by this is, when he was asked if he was the one who committed the crime, he merely denies committing it. Wala na siyang ibang sinabi, hindi siya nag-pinpoint ng ibang tao. Magiging liable ba siya under Article 181 for the crime of false testimony favorable to the defendant? The answer is no. Why? Because the accused cannot be compelled to testify against himself. He can always invoke his constitutional right against self-incrimination. Question: what is the penalty for the crime of false testimony favorable to the defendant or to the accused under Article 181? The penalty shall be as follows: arresto mayor maximum to prison correctional minimum and fine not exceeding 200,000 pesos if the prosecution is for a felony punishable by an afflictive penalty like reclusion perpetua, reclusion temporal, or prison mayor. Or the penalty shall be arresto mayor if the prosecution is for a felony punishable by a correctional and or light penalty like prison correctional, arresto mayor, arresto menor, or by a fine. This is very important. Take note of this. Unlike Article 180, the witness who gives false testimony favorable to the accused in a prosecution for a felony punishable by arresto menor is liable under Article 181, which is not so under Article 180. Here is another matter which is not discussed in your reference books. I'm talking about this question. Do Article 180 and Article 181 apply only when a witness falsely testifies in a prosecution for a felony punished under the RPC, and not when the prosecution is for a violation of a special penal law? The answer is, it depends. Under Article 180, while the provision uses the phrase any person who shall give false testimony against the defendant in any criminal case, take note of the underscored phrase, in any criminal case, it seems that the offender, meaning the person who gave the false testimony, is only liable if the person against whom the false testimony was given is sentenced to a penalty provided for in the revised penal code. Hence, the crime of false testimony against the defendant applies only when the person against whom the false testimony was given is sentenced to a crime that uses the nomenclature of penalties in the revised penal code, like death, reclusion perpetua, reclusion temporal, prisión mayor, prisión correccional, or arresto mayor, or is sentenced to pay a fine or is acquitted. By the way, the penalty of death is already inoperative in view of the abolition of the death penalty. However, under Article 181, the provision uses the phrase, if the prosecution is for a felony punishable by an afflictive penalty and the penalty of arresto mayor in any other case. This means that Article 181 should apply only when the person against whom the false testimony was given is prosecuted for a felony punished under the RPC. For example, X falsely testified in favor of accused Y in a prosecution for illegal cutting of coconut trees. This is a crime or an offense punished under RA 8048 as amended by RA 10593. Question: is X guilty under Article 181? The answer is no, because the prosecution here is for an offense punished under a special penal law, not a felony under the revised penal code. Example number 2. X falsely testified in favor of accused Y in a prosecution for illegal possession of firearms under Republic Act 10591. Question: is X guilty under Article 181? The answer is no, because even if RA 10591 uses the nomenclature of penalties in the revised penal code, still it is not a felony. Article 181 applies only when the person in whose favor the false testimony was given is prosecuted for a felony under the revised penal code. As to false testimony in a civil case, let me start by asking this question. How does a witness deny the truth or say something contrary to the truth in a civil case? In Article 182, which is the crime of false testimony in civil cases, it is required that the testimony must relate to the issues presented in the civil case. It is also required that the testimony must be false and must be given by the witness knowing the same to be false. For example, X testified in a civil case for collection of a debt that Y owed Z a sum of money. The fact is that X knows that Y does not owe Z any sum of money, yet he testified that Y owed Z. Another example. In the problem above, what if X does not actually know whether or not Y owes Z? Will he still be liable for false testimony under Article 182? The answer is no, because in order for X to be liable, the testimony must have been given by X knowing the same to be false. Hindi nga niya alam kung may utang ba talaga si Y kay Z. So, here, he does not comply with the third requisite. And what is that third requisite? That it must be given by the witness knowing the same to be false. Take note that the witness who gives false testimony in a civil case may be a witness for the plaintiff or he may be a witness for the defendant, as the case may be. He may even be a witness for an intervenor, if there is such an intervenor. Another question. When should the witness who falsely testified in a civil case be prosecuted for the crime of false testimony under Article 182? It is only after trial that the court can assess the veracity or falsity of the testimony and correspondingly render a decision. In other words, there must first be a determination of the falsity of the testimony in that civil case before any criminal prosecution for false testimony under Article 182 can be instituted. This is based on the decision of the Supreme Court in Art Travel Express versus Abrugar. The decision in that civil case must first attain finality before a criminal case for false testimony under Article 182 can be filed in court. Reason? The civil case is so intimately connected with the criminal case for false testimony that it is determinative of the guilt or innocence of the accused. I am referring to the person who gave the false testimony. Now, what is the penalty for the crime of false testimony in a civil cases? The penalty to be imposed will depend on the amount of the controversy. Thus, the penalty shall be prison correctional minimum and fine not exceeding 1.2 million pesos if the amount in controversy in the civil case exceeds 1 million pesos. Or, the penalty shall be arresto mayor maximum to prison correctional minimum and fine not exceeding 200,000 pesos if the amount in controversy in that civil case does not exceed 1 million pesos or cannot be estimated. So that ends our discussion on false testimony. Please like, subscribe, and share. Thank you.